The Supreme Court chamber grew hushed as Elon Musk approached the petitioner's podium, smoothing his navy blue suit with a rare trace of unease. The tech mogul had chosen to forego his legal team to personally defend his company's pivotal case against excessive federal regulation. Opposite him, Chief Justice John Roberts and Associate Justice Amy Coney Barrett shared discreet looks, noticed by the attentive gallery. "Mr. Musk," Roberts started, his tone heavy with authority, "you've opted to represent yourself before this court, a most uncommon choice." He added, "While permissible, this is neither a tech summit nor a digital forum." A murmur of uneasy chuckles spread through the onlookers. Barrett leaned in, her voice tinged with subtle disdain. "The legal issues we face today are highly intricate. Are you sure you wouldn't rather have your counsel handle this?" Musk stood motionless, his face impassive as the justices subtly questioned his legitimacy before he could address the case's substance. What followed would stun the courtroom, upend decades of legal precedent, and compel even his fiercest detractors to recognize a facet of Elon Musk rarely seen. This was no mere billionaire quirk. It was poised to be one of the most extraordinary exhibitions of legal acumen ever seen in the Supreme Court. Before we explore this remarkable courtroom clash, be sure to hit subscribe and enable notifications for our latest breakdowns of today's critical political and legal contests. Chief Justice John Roberts, 69, had led the Supreme Court for almost 20 years, renowned for his cautious conservatism and commitment to safeguarding the court's integrity. With meticulous preparation and vast constitutional expertise, Roberts had steered the court through a divisive legal era with measured pragmatism, rarely caught off guard in his domain. Justice Amy Coney Barrett, 52, the court's youngest member, had swiftly proven herself a powerful intellect since her contentious 2020 confirmation. A former Notre Dame Law School professor with a strict textualist lens on constitutional matters, Barrett was known for piercing questions that often revealed flaws in advocates' arguments. Together, they embodied the immense authority of the nation's highest court, an institution that had humbled even the most seasoned legal minds. Facing them was Elon Musk, 53, the polarizing tech visionary whose enterprises had transformed electric vehicles, space exploration, and social media. More recognized for his engineering feats and erratic public remarks than legal prowess, Musk had astonished the legal community by dismissing his elite attorneys and requesting to argue his case himself before the Supreme Court. The case, ex rel. Federal Communications Commission, tackled intricate issues of the government's power to regulate digital speech platforms. Lower courts had repeatedly ruled against Musk's company, upholding recent FCC content moderation rules as valid exercises of federal authority. The financial implications for Musk's firm were staggering, potentially billions in compliance costs and sweeping operational changes. Yet the personal stakes for Musk were just as high. Long criticized as a brilliant engineer but a reckless thinker beyond his technical domain, this Supreme Court appearance was either a peak of hubris or a chance to prove his intellect reached far beyond spacecraft and electric vehicles. "Mr. Musk," Roberts continued, "this court's time is precious. I trust your choice to argue personally won't squander it." The Chief Justice's tone suggested he saw Musk's presence as a spectacle, not a serious legal effort. Barrett chimed in, "Your former counsel's briefs were quite comprehensive. I'm curious why you deemed them insufficient." Her question was a subtle snare. Either Musk would disparage his own team or admit his appearance was superfluous. The courtroom grew tense as Musk adjusted the microphone. Spectators exchanged looks, most anticipating an awkward performance from a billionaire out of his element. Unbeknownst to them, Musk had spent the prior 6 months preparing with a focus that even his inner circle hadn't fully grasped. "Thank you, Justice Barrett," Musk responded, his voice calm and formal. "I deeply respect my legal team. However, this case lies at the nexus of constitutional law, technological innovation, and the future of human communication, areas where I believe I can provide this court with unique perspectives that even the most adept attorney might struggle to convey without first-hand experience building these systems." Several justices sat up, slightly surprised by the composed reply. This was not the impulsive, tweet-driven Elon Musk many had anticipated. Moreover, Musk pressed on. "The matters before this court today go beyond standard legal analysis. They demand an understanding of how content moderation algorithms operate, the practical limits of artificial intelligence in distinguishing protected from unprotected speech, and the global ramifications of American digital regulation." Roberts and Barrett shared another glance, this one less assured. As Musk organized his notes, the courtroom's mood subtly shifted. What had started as an effort to humble an overbold billionaire was becoming something unforeseen. "Mr. Musk," Chief Justice Roberts began the questioning, "your company's primary claim appears to be that the FCC lacks statutory authority to enforce these specific content moderation rules. Yet the Communications Act explicitly grants the Commission broad power to regulate interstate communications. Why should this court carve out an exception for your platform?" The question aimed to put Musk on the defensive immediately, a tactic Roberts had used to expose unprepared advocates. Musk nodded thoughtfully before replying. "Chief Justice Roberts, I believe a more fundamental issue is at play. The Communications Act, enacted in 1934, predates the Internet by decades. While Congress has periodically revised it, the provisions the FCC invokes were never meant to address algorithmic content distribution or user-generated speech at scale." Barrett interjected, her tone doubtful. "That's a convenient reading, Mr. Musk, but this court has consistently held that broadly worded statutes can adapt to technological advancements not explicitly foreseen by Congress. In Massachusetts v. EPA, for example, we ruled that the Clean Air Act's definition of air pollutant was broad enough to encompass greenhouse gases, though Congress couldn't have specifically envisioned that application when drafting the law. The citation of a complex precedent was clearly meant to probe Musk's legal depth. Many in the courtroom leaned forward, expecting the tech CEO to falter. Instead, Musk responded without pause. "Justice Barrett, I appreciate the reference, and it highlights a key distinction. In Massachusetts v. EPA, the court found that greenhouse gases fit directly within the statute's existing definition of air pollutant. The application was novel, but the core regulatory concept aligned with congressional intent." Musk turned slightly to address the full bench. By contrast, the FCC's current push to mandate specific content moderation algorithms isn't merely a new application. It's a fundamental redefinition of the FCC's role from regulating technical infrastructure to overseeing speech itself. This isn't just applying old law to new technology. It's reshaping the FCC's core purpose without congressional approval. Justice Sonia Sotomayor, often wary of corporate arguments, leaned forward. "Mr. Musk, your platform reaches hundreds of millions of Americans. When misinformation spreads on your service, it can influence elections, public health, and national security. Given these stakes, why shouldn't the government have regulatory powers akin to those it exercises over broadcast media?" It was a tough question that had stumped many veteran attorneys. Musk paused briefly before answering. "Justice Sotomayor, that analogy overlooks three critical differences," he began. "First, broadcast spectrum is a scarce public resource, justifying greater regulation. Digital speech platforms face no such physical limits. Second, users actively choose to engage with digital platforms, unlike broadcast signals that enter homes uninvited. Third, the content on my platform is primarily user-generated, not platform-produced, making us more akin to a telephone network than a TV station. Musk wasn't merely holding his ground. He was engaging the justices on nuanced legal distinctions with surprising precision. Justice Neil Gorsuch, known for his distrust of administrative overreach, asked, "Even accepting your statutory arguments, Mr. Musk, why shouldn't we defer to the FCC's technical expertise under Chevron deference principles?" This question delved into a complex area of administrative law, the doctrine governing when courts defer to agency interpretations of ambiguous statutes. Musk's response was swift and precise. "Justice Gorsuch, I believe this case involves exactly the kind of major question that this court has repeatedly held lies outside Chevron's scope. In West Virginia v. EPA, this court clarified that for issues of vast economic and political significance, we shouldn't assume Congress delegated such authority without explicit intent." He continued, "Without notes, the FCC's rules would fundamentally alter how nearly 2 billion people globally communicate. They'd force my company to overhaul its core technology and effectively allow a federal agency to indirectly regulate protected speech. If that isn't a major question requiring clear congressional authorization, I'm hard-pressed to imagine what is." The justices began exchanging looks. This was not the performance they'd expected. Barrett, in particular, seemed increasingly intrigued, her initial skepticism softening into genuine interest. "Mr. Musk," Barrett said, her tone now less dismissive, "your briefs reference Professor Lawrence Lessig's concept of code as law, the notion that software architecture regulates behavior as powerfully as legal codes. Can you explain how that theoretical framework applies to the regulations at issue?" It was a sophisticated question, venturing beyond strict legal doctrine into legal theory, seemingly designed to test Musk's preparation. What followed left the courtroom in awe. Musk stepped slightly from the podium, his demeanor shifting from defensive to commanding. "Justice Barrett, I'm glad you raised Professor Lessig's framework, as it underscores why traditional regulatory approaches falter in digital contexts." Without notes, Musk delivered a nuanced analysis blending constitutional principles, technical details, and regulatory theory. When the FCC mandates specific content moderation algorithms, they're not merely regulating business practices, they're embedding law into the Internet's architecture itself. This distinction matters because algorithmic regulation operates invisibly, continuously, and without the procedural protections of traditional law enforcement. He illustrated with a technical yet accessible explanation. Consider Section 4B of the regulation, which requires platforms to reduce the visibility of potentially misleading content. This seemingly simple rule forces us to build preemptive filtering systems that, by necessity, restrict speech before any legal determination of its status. Musk then shifted to constitutional analysis. This creates a prior restraint issue, which this court has consistently subjected to the highest scrutiny since Neer versus Minnesota. Unlike traditional regulations that penalize after a violation, algorithmic mandates censor proactively based on probabilistic judgments. The courtroom was utterly silent. Even the most skeptical observers could see Musk wasn't merely reciting prepared remarks. He was synthesizing complex legal doctrines with technical expertise in a way few Supreme Court advocates could match. Chief Justice Roberts leaned forward, his initial condescension replaced by genuine interest. "Mr. Musk, that's a compelling theoretical framework, But let's address practical application. How would you propose regulating genuine harms, like coordinated disinformation campaigns by foreign governments, without the algorithmic requirements you're challenging? It was a question that often prompted advocates to retreat to vague principles or concede the need for some regulation. Roberts likely expected Musk to struggle with the policy implications. Instead, Musk offered a surprising alternative, a detailed regulatory framework crafted to balance government concerns with constitutional limits. Chief Justice, I believe there are three constitutionally permissible approaches to address those legitimate concerns, Musk replied. He outlined a sophisticated plan involving transparent disclosure requirements, user empowerment tools, and narrowly targeted enforcement against specific illegal content categories. The technical precision was impressive, but what captivated the court was how Musk anchored each proposal in existing Supreme Court precedents and statutory authorities, citing cases and provisions with the ease of a veteran legal scholar. Justice Barrett, whose initial skepticism had been most evident, asked a follow-up that signaled a notable shift in her view. Your framework is intriguing, Mr. Musk. It seems to draw on Justice Kennedy's concurrence in Packingham versus North Carolina regarding the Internet as the modern public square, while also acknowledging the government's interest in preventing specific harms. Have you considered how your approach would be implemented given the current statutory landscape? It was a question that treated Musk not as an overconfident novice, but as a serious constitutional thinker. Musk's response showed not just legal knowledge, but strategic depth. Justice Barrett, I believe the existing authorities under Section 5 of the Federal Trade Commission Act already provide a statutory basis for the transparency and disclosure components. For content-specific regulations, narrowly tailored amendments to Section 230 would be more appropriate than FCC rulemaking. He continued with remarkable clarity. This approach respects the separation of powers by keeping Congress, not administrative agencies, as the primary architect of Internet governance policy, a principle this court emphasized in FDA v. Brown and Williamson Tobacco. What had started as an effort by Roberts and Barrett to humble an overconfident billionaire had evolved into one of the most sophisticated constitutional dialogues the court had seen in recent memory. Musk wasn't just holding his own. He was advancing novel legal frameworks that visibly intrigued the justices. The Solicitor General, defending the FCC, appeared increasingly uneasy as he observed the justices' engagement with Musk's arguments. What should have been a routine defense of agency authority had become a challenging battle against an unexpectedly formidable opponent. As Musk wrapped up his arguments, Chief Justice Roberts, now fully engaged, posed one final question. Mr. Musk, given your technical expertise, can you specifically address why the FCC's approach to algorithm regulation is not just legally problematic, but technically flawed? It was an ideal opportunity for Musk to merge the legal and technical aspects of his case. For the next 4 minutes, he delivered a masterclass on how content moderation algorithms function, the limits of AI in distinguishing protected from unprotected speech, and why the FCC's mandated approach would inevitably overblock legitimate speech while underblocking truly harmful content. The technical explanation was so clear and expertly delivered that even justices with limited tech knowledge could understand the practical issues with the regulation. Musk concluded by tying the technical concerns back to constitutional principles. In essence, the FCC is mandating a technical solution that cannot achieve its stated goals without significant collateral damage to protected speech. Precisely the outcome this court's First Amendment jurisprudence has consistently sought to prevent. As Musk took his seat, the courtroom remained quiet, observers processing what they'd just seen. The expected embarrassment of an overconfident billionaire had instead become a stunning display of legal and technical mastery that visibly impressed the court. Barrett and Roberts shared one final glance, this one acknowledging they had gravely underestimated the man before them. Within hours of the arguments, legal blogs and news outlets were flooded with headlines like "Musk stuns Supreme Court with unexpected legal brilliance," and "Tech billionaire outmaneuvers nation's highest court." Video clips of the most striking exchanges spread rapidly across social media, with legal experts expressing shock at Musk's performance. "I've watched Supreme Court arguments for over 3 decades," said Harvard law professor Lawrence Tribe on a cable news panel. "And I can say without hesitation that Musk's presentation ranks among the most impressive I've seen from a non-attorney." The integration of technical knowledge, constitutional theory, and case law was remarkable. Legal Twitter buzzed with analysis from stunned court watchers. The moment when Musk cited Justice Kennedy's Packingham concurrence and tied it to Lessig's Code as Law framework was extraordinary, wrote a prominent appellate attorney. He wasn't just reciting memorized points. He was synthesizing complex legal theories in real time. Court insiders reported that during the justices' private conference after the arguments, the discussion was unusually lively. Though deliberations remain confidential, sources close to several justices suggested Musk's arguments had significantly shaped the conversation, with multiple justices expressing surprise at the depth of his legal analysis. 3 weeks later, the impact of Musk's performance became even clearer when the court requested supplemental briefing on several of the alternative regulatory frameworks he had proposed, a rare move signaling the justices were seriously considering his ideas rather than deciding the case on existing arguments. Legal scholars began publishing analyses of the Musk approach to tech regulation, exploring how his framework might reshape the relationship between government agencies and digital platforms. Law school professors added the oral argument recording to their constitutional law syllabi as a case study in effective advocacy. For Barrett and Roberts, the experience prompted subtle but meaningful shifts. In subsequent technology-related cases, both justices showed noticeably more humility when questioning advocates about technical matters. Barrett reportedly told students at a law school visit that the experience had been a valuable lesson that legal expertise comes in many forms, and assumptions about who possesses it can be misleading. Roberts, speaking at the American Law Institute months later, made what many saw as an indirect reference to the Musk argument. The bench and bar must increasingly recognize that as technology transforms society, the most valuable legal insights may come from those who understand that technology from the inside, not just those trained in traditional legal analysis. For Musk, the Supreme Court appearance marked a significant shift in his public image. While still controversial for his business decisions and social media presence, he had undeniably established himself as more than a technical innovator or wealthy provocateur. Constitutional scholars and legal commentators who had once dismissed him began engaging seriously with his ideas on technology regulation and digital rights. 6 months after the oral argument, when the court issued its 7-2 ruling in the case, it largely adopted Musk's position. Justice Barrett, writing for the majority, cited his technical explanations repeatedly and incorporated much of his framework for distinguishing between permissible transparency regulations and unconstitutional algorithm mandates. Most notably, Barrett's opinion concluded with a paragraph many saw as a direct nod to Musk's contribution. As technological innovation continues to transform how Americans exercise their First Amendment rights, courts must be willing to reconsider traditional regulatory frameworks and remain open to insights from those who create and understand these new channels of communication. The complex intersection of code and law demands both legal humility and technical precision. The case would later be included in constitutional law textbooks, not just for its substantive holdings, but as a turning point in how courts approached regulating digital speech platforms. What had begun as an attempt to humble a presumptuous billionaire had instead launched a new chapter in American legal history, one that recognized the need for interdisciplinary approaches to constitutional questions in the digital age. Legal commentators later identified the case as the start of Musk jurisprudence, an approach to technology regulation emphasizing transparency and user choice over government-mandated algorithms and requiring regulators to work with, not against, the technological realities of digital platforms. For the legal establishment that had initially dismissed him as an amateur, the lesson was clear and sobering. In an era where technology and law increasingly intersect, traditional legal credentials may be necessary, but are not sufficient. Sometimes, the most profound legal insights come from those who understand not just what the law says, but how the systems it seeks to regulate actually function. What began as an effort by two Supreme Court justices to put an overconfident tech CEO in his place had instead revealed a legal mind of unexpected depth and sophistication, potentially reshaping the constitutional framework for digital speech regulation for generations to come. If you found this analysis of Elon Musk's surprising Supreme Court performance insightful, don't forget to like and subscribe for more coverage of where technology meets law and politics. Share your thoughts in the comments below. Do you think tech innovators should have more direct input in how their industries are regulated? Your support helps us continue bringing you in-depth analysis of today's most important legal battles.